Okay, everyone. So this is, the class that I will be taking that will be with regard to previous year law optional discussion. Now, each year I do it, right? Last year also I did it. Now this year again, the paper one was quite easy, right? And second, paper two was also quite easy. A little bit, one or two bounces were there, like there were question with regard to crime, right? Murdering of girl and then, having raping her. So what kind of law will apply there? So that part was a little bit tricky because in our scheme of things, that is your IPC, necrophilia is not an offense, right? So that was a little bit tricky. Otherwise, more or less, paper were quite good. And constitution part was very good, Chaitanya. Yes, you are very correct. And most of the questions are very, very easy, right? So let me, what I will do, yeah, everything from my class. You are the student of foundation class. Okay, okay, right now, as I keep telling you, right, you don't have to read too much, right? Just be very specific that what you have to study, and ultimately you will be, able to solve everything. Okay, so let me share the screen and start the class. Okay, so let me share the screen. So hopefully everyone can see the screen, right? Everyone can see the screen, I suppose. Okay, okay, done. Chलिए, so let us start. Yes. Oh, so I can see few students who are already, have given exam this year also here. Okay, that's good. Chलिए, so let us start with the class. Now, if you look at the question number one, right? Question number one suggests the preamble of the Indian Constitution is indicative of the basic values that our political system expected to pursue. Right? Now, this particular question, how far do you agree with the statement? Explain with the reference to the values that have been enshrined in the preamble of the Constitution. Now, same question if I ask you, okay, what are the major aspect of the preamble? You will write the same thing, right? You will all write all the keywords in detail along with one case. Same thing you have to write. In fact, last year there was a question, the basic structure and preamble, what are the common things that is there, right? There also you should have written, okay, secularism is a basic structure, democracy and republic character is a basic structure. Here also you have to write the same. Even the question seems like different, the only content that will change is with regard to here you have to justify, right? These are the things which the Indian Constitution and preamble provides, which the political structure is supposed to follow. Getting my point? The political system is supposed to follow, right? Otherwise, question literally remains the same. So, how will you approach this question? So, very nicely, what you will do that you will simply write, okay, preamble provides for following, right? So, you will write sovereignty, democracy, republican character, right? Secularism, and then you will simply explain them along with one cases. Like SR Bomai would be mentioned the secularism. Right? So even if you write 4 to 5 of them, 150 marks would be 150 words is there. Okay, so you need not to write more than that, right? So this question is similar to what they have asked earlier. So they have asked their preamble and basic structure. So all these major things are actually part of basic structure also. So only the heading has to be changed. Okay, these are the basic structure, and you have to write the same thing. Okay, so ultimately the question is same. Getting my point? Yes. That's what it was a very good, easy. Obviously, I will be preparing model answer also, right? So they will be selling you the model answer, right? I mean the books, obviously. So if you want, you can buy them. Otherwise, you can do it by yourself also. That's all. Okay. Now let's come to the next question. The question number 2, 1B. Office of the President and the Indian Constitution have been designated largely as figurehead. Now, if you look at our syllabus, there is a topic called nature of the president's office. Okay, so what you have to do, so you have to, here in this question you have to simply compare them with the British monarchy, that how it was intended to be serving as a figurehead or equivalent to the British monarchy. And then you could write the constitutional assembly debate where this figurehead concept have been justified by B.R. Ambedkar, right? So you can write a quote from him that okay, the Indian constitution merely they are the figurehead. Then you can go on and talk about Supreme Court cases, right? So there are two specific cases I would request you to look at it, right? The first cases was with regard to this Samsher Singh, right? So Samsher Singh, whereby the some kind of grant was given by permission was given by the president on the advice of Council of Ministers. Now the question was that can the president apply his own mind? The answer was that no, right? Supreme Court simply said that it is something which is a figurehead, and whatever the Council of Ministers decides, the Supreme Court have to simply follow it, right? So there are multiple questions like that, like if you can cite this case of this R.K. Lakshman with regard to Tamil Nadu, the reference that was given by the president, right? So there was a case whereby it was asked that whether the reference can be given by president to the Supreme Court on its own. The answer was no. It has to be done on the advice of the Council of Ministers, right? So 2-3 cases you can simply write, right? So very nicely, you can do it. It is not something which is actually tough, right? Okay. Thereby, now the next thing that you have to see is that now who is making this? I think okay, right? So it is quite simple, quite easy. Now let us come to yes. This will be up. This whole thing will be. I'm recording it. It will be on the YouTube. Not to worry. Okay. Now let us come to the question number 3. Now what is question number 3? Now question number 1C basically it says there is obviously a slant. Let me re-share actually because someone has in between done something and that has led to. Okay. Now if you look at this, it says that there is obviously a slant in the favor of the center in the distribution of power between center and states. Very simple question, right? That is why I keep saying UPSC is different. In the case of UPSC, you need not to go in detail. Here, what you have to do, you have to simply identify division of power, that is with regard to legislative power, chapter 11 of the Constitution we are talking about, and executive power. You have to simply cite articles, how it is in the slant or it is in the favor of the union. Right? So it is sort of a precursor of one of the part of this question related to unitary and federalism. Right? One of the content of that particular answer is actually this division of power. Right? So you have to cite that how there is overbearing presence of the legislature in terms of, legislative power in terms of lawmaking, right? In the case of emergency, parliament can make law. In the case of if in the case of national interest, in the case of enforcing of the treaties, okay, parliament can make law. All those articles related to 249, 250, 252. Similarly, with regard to executive power, that how the state has to follow the instruction of the union and how the state executive have to mandatorily execute the law of the union, right? So all those articles you have to simply write that down one by one article and thus provision very brief. Yes, very correct, Ayush. 246 to 251, right? So again, a very easy question that was, right? You could have very easily written it. No need, Himanshu. Mention ambit of the list. No, it is simply impossible, right? It is 150 marks, right? So even though mentioning articles and one line about it is more than sufficient, right? If you start writing ambit, 150 marks, 150 words will be already over. Okay, you have to simply pinpoint articles, dash this, article, dash this. Okay, just it, not more than that. Now let us come to 1D. The principle of natural justice are not cast in stone and there is always a possibility of deviation from a stated principle. Last year, same question was there last year. The principle of natural justice is flexible. See, this and that question is exactly the same. That is why I keep on repeating you. Right? UPSC always repeat question. Now I have taken the feedback of other optional, right? And I have got this feedback, the questions are quite tough. But in UPSC, it is exactly the same. Right? It is flexible. Now this, it is not cast in stone, always a possibility of deviation. It is the same question. Right? It is flexible, or like this year, I think I have also asked this question. If you look at this number somewhere, right? So I have also asked this question someone with regard to this, right? I will show you later on, right? Now, how will you approach this answer? So there are two things you have to write. First, there are a lot of exceptions. That is why it is flexible, right? In the case of emergency, etc., etc. Similarly, in the case, second thing, that new principle of natural justice keep on evolving, right? So you can write, okay, post-decisional hearing has become the part of principle of natural justice. You can write that how recent decision has become the part of principle of natural justice, right? So two things, exceptions make it flexible, and second thing is that new things keep adding on, right? So these two things would be more than sufficient along with one case, right? So again, it is a very, very easy question, right? Yes, very correct, Tanya. You have to write simply exception number 1. In the case of emergency, explain, bracket, name of a case. Right? So again, quite simple. Okay. Now let us come to 1E. Now 1E is that elucidate the ground of judicial review of administrative quoting decided cases. Right? Now if you look at this ground, illegality, irrationality, again, quite simple. Right? These are the grounds available. Explain the ground, a case. Irrationality, explain the ground, a case. Procedural impropriety, ultra vires the parent act, etc., etc. Simply write the explain one case. Explain one case. That's a model answer has to be prepared. And this is a question which keeps on repeating, right? Which is something which keeps on repeating. Like this, I think in test number somewhere I must have given that this year. In fact, I have given a question that what are the grounds of judicial review administrative action? It is the same question. Last year also the same question was asked, what is the ground of judicial review of administrative action? This is the same question. Getting my point, right? So there are multiple grounds, even though you can write 4 or 5 of them along with this explanation in one case, that is more than sufficient. Right? Yes, whatever I have predicted in class. I mean, I don't know how UPSC frame questions. Simply by looking at the PYQ, you can understand what kind of question UPSC frames. Okay, so it is not something out of the blue or something like that. Again, quite easy. Okay. Now let us come to question number 2A. It is a little bit longer. Now this question number 2A is with regard to Constitution of India. Yes, Rasi, you can. Unitary federal, you can or you don't. I mean, this is the part of that. So you need not to frame all the, I mean, you don't need not to write all the federal or unitary provisions. Okay. ऐसा लग रहा है पेपर आपने सी श्रेयस मैंने पहले भी कहा है और जो लोग फाउंडेशन बैच के नहीं उनको मैं बता रहा हूँ होता क्या है कि इन अ पर्टिकुलर टॉपिक यू कैन नॉट फ्रेम मोर देन 3 क्वेश्चंस इट इज सिंपली इम्पॉसिबल राइट लाइक दिस जुडिशियल रिव्यू ऑफ एडमिनिस्ट्रेटिव एक्शन so either they ask you overall okay what are the judicial review what are the grounds applicable or they go in detail about each ground that's it now, apart from that there is no question that can come from no matter how innovative they can simply innovate the wordings of the question like this. They can simply innovate the wordings of the question. Otherwise, the question actually remains the same, right? Like same thing in the case of principle of natural justice. There are 2 questions they ask. One individually on each principle, and one overall. It is flexible, right? It is it keeps on evolving, right? So it is the same question that they have asked. Okay, so never ever you will get a question which is new, right? 1, 2 bounces are there in paper 2, but paper 1 is mostly on decided lines. Okay. Now let us see question number 2A. Now question number 2A, yeah, very correct. Question number 2A says that Constitution of India has provided a clear-cut distinction between civil and political rights on one hand, economic and cultural right on the other, with a distinct primacy given to civil and political right explained. Now, people would quite surprised that ye kya pooch diya, right? But if you look at very closely, in fact, those who are foundation, they must be remembering जिसको मैंने इंटरनेशनल लॉ पढ़ा दिया है. I always tell you there are 4 generation of rights. Pehla, bodily rights, the things which are closely related to body, arrest, detention, etc. Then the second rights come is basically social rights, right? Economic rights. Then comes the collective rights, as a whole, as a society, what do you want? And then comes individual right, that is right of disabled person, right of child. So this is called first generation right, this is called second generation, this is called third generation, this is called fourth generation. So our constitution, the first generation rights are basically fundamental rights. Second to fourth generation rights are basically what? DPS. So this is a question which I are asking you, give me the distinction or you can say interrelationship between DPSP and fundamental. Okay, so it seems like a very tricky question, but it is not a tricky question. Right? So it seems like, okay, kya pooch diya? But they are asking, okay, first generation rights, like for example, civil and political right is given under the part 3, that is your fundamental right, and rest of them is in part 4, second, third, and fourth generation rights. So you have to simply qualify and quantify and name them. Okay, these are the civil and political rights, and these are which are economic and cultural rights, right? And then you write one particular case that, okay, in India, this have been given primacy. Very, very famous case one Bharti, or you can even go with regard to this Thomas case, right? So it is again quite a simple question. Okay, so again, nothing. But I go through, yeah, it seems fine. Yes, Chetan, very correct. It is, quite easy. So this 2A is clear for everyone. So I proceed further. Again, quite an easy question, interrelationship. Now let's come to 2B. Panchayati Raj institutions and urban local bodies have accorded constitutional status. Explain the ambit and structure authority of Panchayati Raj and urban local bodies. Simply write Panchayati Raj provisions. Now, if you remember, those are a foundation batch. I have very nicely in Panchayati Raj made a 3-layer, right? Panchayat Samitis, Gram Sabha, etc. Second layer and the last layer. Right? Make the layer, write in bracket name of the articles, right? Then you write, okay, there are certain recommendatory measures and there are certain which is mandatory measures which have been provided in the constitution, right? So recommendation, mandatory. Okay, so you have to simply pinpoint recommendation, mandatory along with the article. Okay, so it is again a very, very easy question. You can simply write it down. Yes, Acha, Mazhar is again of the law of foundation. Okay. Now, yeah, it is a polity touch, but articles has to be written along with it, right? Articles has to be written. Yes. Now, let us come to the next question. Next question is articles has to be written, Archie, right? Articles has to be written. Otherwise, the questions, yes, you are very correct. It seems like more of a polity one. Okay, now let's come to question number 2C. It says, the Constitution of India provides a constitutional status and protection to civil servants, right? Every time, last year also. What are the constitutional safeguards? Civil servants. Civil servant cannot be dismissed because of certain safeguards, right? So these are the different type of structure that you can, I mean, question can be framed, but the answer will remain the same, right? Security of tenure, security against removal, right? Must be reasonable opportunity of being heard, right? So these all simply headings, articles, explanation, a case. Heading, article, explanation, a case. Right? Only probable question is very. नहीं कभी-कभी in this they ask you, if you remember Chatan, कभी-कभी ये भी पूछ लेते हैं, right? That doctrine that applies in the UK is not applied in the absolute rigidity in India, right? कभी-कभी ये question they ask, right? Otherwise it is literally the same. Okay. चलिए, now let's come to question number 3A. Now, question number 3A again is quite a simple question. It says superintendent's direction and control of the election commission. My teacher said law is quite tough for cracking UPSC. Huh? Yes, you should ask some of the students who have cracked it. Okay. क्या चले वो सब बाद में बात करेंगे आर्ची. Let us first finish the questions. Now what does it say? It is basically provision of the constitution, right? If you remember article 324 lining. Critically examine above with reference to recent judicial decision. I have also asked in this test, I mean, the test series that has gone by Anup Badwal, right? That was the judgment that has come, right? Anup Badwal. How we will start this particular question? So we will first write what is the meaning, right? I always tell that you should always and always try to find some of the good lines, like with regard to this election commission. You should also always start with that. See, you are a person, in a constitutional democracy, always and always there is a mechanism to protect the constitutional ethos or democratic principle. Election commission is one of them. So this is such a generic line. That line you can write in the introduction part, and then you can go and talk about how election commission basically provides the regulation to election at 3 layers, right? First, pre-election, during election, along with the article, and post-election. In post-election, you can talk about solving election disputes. Also, you can talk about delimitation exercises, right? So during election, campaigning, regulation of campaigning, and pre-election, preparation of electoral roll. Then you can talk about deciding on election petitions with regard to formation of political parties, symbol, etc. Right? So along with the provisions, you can simply write one cases in each one of them. And then you can write a recent development and simply write Anup Barwal, right? And lot of constitutional morality, the judgment, lot of good lines are there. If you, if you have given mains, I have already supplied you a very good previous year compilation of this major judgments of each topic, right? So that actually you can write here. That is more than sufficient. Okay. Now let us come to 3B. Arsika, let me first discuss this. I have made lot of videos, okay? This tips with regard to how to write answer, etc. You go and watch it, okay? First, let us concentrate here. Ultimately, same question might be repeated again, okay? So first, let us concentrate here. Everything else, I will tell you, okay? So not to worry about it. Let us first concentrate. Yes. Now let us come to question number 3B. Now, what is this question number 3B? Question number 3B says legal aid basic tools for accessing of this and date constitutional provision of Legal Service Authority Act. Right now, this Legal Service Authority Act and constitutional provision, this was asked in GS paper 2 also. Right. So first you have to talk about constitutional provision. You have to write judgments like Hussain Ara Khatun, connecting Article 20 and Article 14 with legal aid, how access to justice is a part and parcel of the fundamental right. Then you will come to the DPSP provisions and write that how Article 39A have been inserted, which provides legal aid, provision for legal aid. Then you will come to the statutory provisions, right? And then the statutory provision, you will write Legal Service Authority Act. So what are the major provisions of Legal Service Authority Act? So we'll talk about, you know, 3-layer legal service authority. There are people who are freely eligible for the aid. Then you will be talking about lok adalat, permanent lok adalats. Okay. So very nicely structured. First, constitutional provision. You will write fundamental right and legal aid, UPSC and legal aid, headings I am talking about. Then statutory provisions, major feature of the Legal Service Authority Act, right? So what are the major? Yes, DALSA, NALSA, 3-layer, that is what I am talking about. Then lok adalat, permanent lok adalat. Right, that is more than sufficient. Now, if you want to fetch that half or 1 marks additional, you have to write in bracket name of the articles or the sections of that particular law. So like, you know, very nicely Jitendra is saying section 12, right? Section 12 is very correct. Okay. Now let's come to question number 3C. Now again, it seems like very, you know, tough question, but let us analyze. It says, the strength of eminent domain is inversely proportional to the strength of democratic structure of any system. Do you agree with this statement? Explain. Now, the same question was asked last year. What do you mean by eminent domain? Do you think it is relevant in modern time? Right? So what do you refer by modern time? It is simply asking that India is based on liberalism, right? The political philosophy of liberalism, which gave the rise to the concept of democracy, right? Which gave rise to the concept of democracy. Now, one of the fundamental aspects of liberalism is that a person should be free to possess property. Now, eminent domain says that no state can acquire property at their will. So, do you think they are at odds? So, the question of last year and this year, almost 80% substantially it is same. Again, I am repeating. Democracy is based on one of the foundational principles of liberalism, and one of the aspects of liberalism is to have freedom to individual to acquire wealth. Eminent domain says that, see, the state can take your wealth as the wish, right? So they are at odds. Same question was asked, do you think it is relevant in India today? Right? So that question and this question is exactly, you know, more or less on a philosophical level, the argument remains the same. ये बात समझ में आई सबको? Yes? The argument with regard to the question, do you think it is relevant in India today? And this question, they are odds with the democratic principle is actually the same. Yes, Chaitanya, ये बात समझ में आ रही है? Mazhar, yes. So it is exactly the same, right? So what you have to do, you have to first start with, okay, meaning of eminent domain, tell us properly, you know, that line. Then you have to talk about constitutional manifestation. Then you have to simply write the case law and that philosophical line that how both are not at odds. You know, then you can cite the, you know, law that like this Land Acquisition and Rehabilitation Act, that how it balances them. When there's a Ranga Reddy collector, Ranga Reddy district case, right? So that is, I think, more than sufficient for this. Okay, now let us come to 4A. What do you understand by the breakdown of constitutional machinery, Article 356? Critically examining the power of president, imposing president rule, citing by deciding cases. Right now, there is only one case. If you remember, the most famous was that is SR Bomai. So how will you start it? First, you will write one of the provision unique to the Indian constitutions, and it is sometimes considered against the federal spirit. Then constitutional provision, right? 356, exactly what does it say? Then write meaning of the word failure of breakdown of the constitutional machinery. Then you write it have been often misused, but Supreme Court through judicial decisions has pinpointed grounds which will be counted as a failure of constitutional machinery and the grounds which would not be counted as a failure of constitutional machinery. Right? Like defeat in Lok Sabha is not a ground, breakdown of law and order is not a ground, but secularism under threat can be a ground, defeat of money bill can be a ground, horse trading again is not a ground. Okay, so you have to simply write, okay, these are the grounds the court have said it is correct. I mean, it is a proper ground and these are grounds which is improper. So you have to simply write these are the proper grounds and these are the improper grounds. And then you have to conclude that court through judicial intervention has watered down the scope of its misuse. Watered down the scope of its misuse. Yes, Amit, very correct. Jitendra is also very correct. State of Rajasthan, President of India. Maharashtra case also you can mention. Okay. So very nice structure, constitutional provision. Then you have to write meaning of breakdown of constitutional machinery, things which will be considered breakdown, scenario which will be not considered breakdown, scenarios, cases, and in last, how judicial interpretation has actually watered down the impact of this misuse of this particular provision. So very nicely structured answer. I think मुझे लगता है foundation में I have given this question to write you guys also, right? Huh? Chetan, I think I have given this question. Okay. Chaliye, let us come to 4B now. Discuss the objective and establishment of Lokpal and Lokayukta and their power and function. Every time there is the same question. Lokpal, Lokayukta, power function, right? Every time. There is no another question. Sometimes they ask you critically evaluate their functioning, effectiveness. Same thing. Right? So what you have to start with, you have to talk about objective of Lokpal, to combat corruption, public accountability, providing for transparency. Then power and function, you write what is the jurisdiction, investigation, along with the article in bracket. Okay. Then effectiveness. In effectiveness, you can write, okay, it is a limited power, like with regard to taking cognizance of prime minister's corruption against prime ministers is a very, very, very tough thing to do. Similarly, you can write with regard to delayed appointment, non-appointment of Lokpal and Lokayukta. There is inadequate infrastructure. Lokayukta, they appoint, but they don't even give them any office to function. Right? So lot of things, almost GS type you can literally write it. Okay. Nothing more than required. Okay, sir, is it recommended to write the year of the case? No, not at all. The year of the case is important only when we have to sort of trace down the development. Like if there's a question, you can trace the development of case one on Bharti. Then you have to write year of, Secretary Prasad. Otherwise, the year is not. Okay, now let us come to 4C. Again, quite a simple question, 4C. Now, 4C says, if at any time it appears to the President that a critical question of law or fact have arisen, the President can obtain the opinion. This is a question. Write a short note on Article 143. Right? What you have to do, you have to first talk about meaning of 143, what does it provide, and then you have to provide rationale. Okay, yes, then you have to provide rationale, why it have been provided. Yes, May versus L, very correct. Then you have to talk about examples in which the reference have been provided, lot of Kerala Education Bill, then Berubari Union case, then this Ayodhya, that is also in reference to that, right? So lot of reference can be given, that is very easy. Then you will come to next question, that is question number 5A of international law. Now, my last, it is not binding yet. Obviously, the provision itself, 143 provision itself, you will write it down. Then you will come to, so see, all of the questions is almost, quite easy. Like if you look at, let me take any of the test. I think one of the tests of Harshit was quite good. Look at the questions. If you let me show you some of the questions of full length. Life and personal liberty. Secularism is a part of secularism question. This time they haven't asked it. Appellate jurisdiction. See? Same question. What are the grounds on challenging of administrative acts? Right? And this is something they ask you every time. It is not something which is unique in nature. Right? They ask you every time. Right? Similarly, principle of natural justice is flexible. This pardoning power they have not asked. It is exactly the same. It's exactly the same. Nothing else is required. See? Panchayati Raj institution, local governance. Right? So now what I do also that I simply give you the questions of previous year. Right? Because I know UPSC is going to repeat it. No, I don't try to become hero and give you unique questions which are not required. Okay? Catch it. Now let us come to the questions. Let us see. Of international law. We will start with the international law. Triumph of positivism has reduced an individual to be objective of international law rather than subject of international law. Comment on the status of individual and international law in light of the above statement. The question is simply asking what is the status of individual and the international. That's it. That is the question. Now you might say, what is this positivism? Now positivism is one of the traditional concept on this is a topic related to basis of international law, positivist theory. In that concept, it was assumed that international law is a law between sovereigns. Yes, Austin is one of the believer of that. Now here it says that nowadays this concept is very narrow, that international law is a law between sovereign. Meaning now not only the states are the subject, but the individuals are also subject of international. So we will start with positivism. Positivism, you will simply write, okay, positivism means is based on the premise that international law is primarily created between sovereign states. However, with the change of the time and the changing character of international law, individual has also become the subject of international. Okay, full stop, khatam. Only this. Then you will write individual as a subject and fill it with example. Right? Then you will simply fill it with examples. How individuals are the subject, right? You can write the example of ICC. You can write human right concept. You can write humanitarian principle concept where the individual is one of the subject of international. नहीं पढ़ती हो आप ओपनहाइम का डेफिनेशन लिखने जाएंगे तो इट विल टेक लॉट ऑफ टाइम. ठीक है, हालांकि लिख सकते हैं कि सिंपली राइट ओपनहाइम एंड ऑस्टिन इज सपोर्टेड ऑफ देम बट लेटर ऑन ओपनहाइम आल्सो चेंज इट्स ओपिनियन. दैट्स इट, राइट? कि jurist also founded कि okay individual can also be one of the subject, right? But you will, if you write his exact definitions, right, so obviously it will be a futile exercise. 150 वर्ड है यार, ओपनहाइम का डेफिनेशन ही 50 वर्ड का है. ठीक है, तो वैसे लिखेंगे तो फिर और चीज के लिए जगह नहीं बची. अंडरस्टूड प्रत्युष? ओके, सो यू नीड नॉट टू यस राइट द होल डेफिनेशन. ओके, जैसा मैंने बता रहा कि positivism says so and so, now individual has acquired importance and then you write examples where individual have acquired importance. That's it. Okay, not इनफैक्ट मैं देख रहा था ये क्वेश्चन और एक अगला क्वेश्चन था, कहीं पे मैंने देखा कि दैट इज योर द डिफरेंस बिटवीन ओल्ड एंड न्यू इंटरनेशनल लॉ. दैट इज एक्चुअली द सेम. ठीक है, खैर आगे देखो. ओके, नाउ लेट अस कम टू क्वेश्चन नंबर 5B. Yes, Jitan, you can give contemporary example. That will be perfect. Contagious zone, Indian practice, right? So we will simply write the contagious zone. If you remember, Article 33 of the clause that provides for contagious zone. We will write what are the provisions, baseline, power and function of the ये मैंने बोला था पक्का है, इसलिए बोला था कि पिछले 2 साल से नहीं पूछ रहा, राइट? डी फैक्टो डी जुड़े पूछ रहा है, तो इस पर मुझे लगा था कि आएगा. इसलिए मैंने कहा था किस पर आएगा. ओके, तो ये आपने लिख दिया है ना, पावर एंड फंक्शन ऑफ द आई मीन राइट्स एंड लायबिलिटीज ऑफ द कोस्टल स्टेट. एंड देन यू विल राइट इंडिया में मैरीटाइम जोन एक्ट है व्हिच ऑलमोस्ट गिव्स द सेम प्रोविजन. ठीक है, वहां भी बेसलाइन अनक्लॉज वाला अडॉप्टेड है, वहां भी जो 24 नॉटिकल माइल्स है मैरीटाइम जोन एक्ट वो भी वो करता है. सिर्फ एक चीज है कि इन मैरीटाइम जोन एक्ट इन यहाँ पे जो फिस्कल लॉज है, राइट, इन अनक्लॉज इट इज नॉट एप्लीकेबल ऑलवेज इन सर्टेन सिनेरियो बट हियर दे आर, राइट? तो अगर आप ये नहीं भी आपको पता है तो आप लिखेंगे ऑलमोस्ट सेम अलोंग विद द सेक्शंस ऑफ द मैरीटाइम जोन एक्ट इज मोर देन सब. जैसे अगर आप जो फाउंडेशन के स्टूडेंट है मैं देखा होगा कि मैंने नोट्स में दिया भी हुआ, you know, this an Indian position. Harik, in the case of all unclosed, whatever the provision is, like for example, this innocent passage or this hot pursuit, Indian scenario. Okay, so this Indian scenario they have asked again 50 to 75 words, provision of unclosed, Article 33, clause 1, 2, 3, 4, and then Maritime Zone Act and simply case अगर चाहे तो लिख भी सकते हैं, otherwise you can skip it. ऐसा कोई इसमें बहुत ज्यादा केस की जरूरत नहीं है. If you remember, obviously, well and good. Okay, impact of recognition on power and place. अब देखिए कितना टफ लगता है, ये नहीं पढ़ा है. आप कह सकते हैं कि भाई ऐसे तो नहीं बताइए इम्पैक्ट. यार तो ये वही बात हो गई ना कि what will happen after recognition, right? So basically they are asking you कि what will happen after recognition. So what will happen, right? You will get legitimacy, diplomatic immunity मिलनी शुरू हो जाएगी. You can access international financial system. You will get membership of UNO, right? So these all are the things which you get once you get recognized, right? So consequence of recognition पूछ दे या impact of recognition पूछ दे, एक ही बात. ठीक है ना, right? So it is again a very general question. You need not to go in detail and write something new. It is same question. Okay, what are the consequences, right? What are the consequences? Okay. Now let us come to question number 5D. Principle of just cogent. Now, those of you who are unaware, just cogent are basically preemptive norms given in Article 53 and Article 64 of the VCLT, which says that there are certain preemptive norms which have their basis in such a manner that it cannot be violated by any state in any manner. Okay, so there are two kind of question comes from just cogent. पहले तो ये कि what are the major just cogent principle, or sometimes they ask you, do you think that just cogent has overburdened or sort of overshadowed the VCLT principle itself? Just cogent basically क्या कह रहा है कि if a just cogent principle is in conflict of any of the treaty will be invalidated. So just cogent has become sort of overshadowed the treaty itself, right? So it has become much larger to treaty. So एक क्वेश्चन वो आता है philosophical basis और एक क्वेश्चन ये कि what are the principle of just cogent. तो क्या क्या है principle of just cogent? So basically there are 3 categories of the principle of just cogent, right? एक, all the major crimes given in ICC statute, right? That is your genocide, torture, etc., etc. Second, principle of humanitarian law, principle of distinction, excessive use of force, etc., etc. And third is the principle given in UN Charter, right? Not interference with the territorial integrity, right? Territorial sovereignty must be respected, etc., etc. Right? So all those things are three categories of just cogent. Right? So you have to simply name them along with examples. Okay, again, quite simple. And you have to write Article 53 and Article 64 of VCIT. If you don't remember exactly the precise format of the article, at least you should be able to mention these are the articles. Okay, that is actually quite important. So my बात ये बात. Yes, everyone understood this particular point? आगे बढ़े हम लोग. Okay. Now let us come to 5E. Now what is this 5E? Now this 5E question is that international court is more of a Eurocentric, right? मैंने भी क्वेश्चन पूछा था कि ICC is not what it used to be, right? अगर आप टेस्ट नंबर 11 देखेंगे किसी का, राइट, जैसे अगर ये 11 ही देख लीजिए तो इसमें मैंने कहीं ना कहीं क्वेश्चन पूछा है, या तो 11 में पूछा होगा, नहीं 13 14 में मैंने पूछा होगा कि डू यू थिंक ICC हैव डन व्हाट इट हैव बीन रिकॉग्नाइज्ड, और डू यू थिंक कि उनको सारी प्रॉब्लम अफ्रीका में ही दिखती है? ठीक है ना, कहीं ना कहीं क्वेश्चन किसी टेस्ट में, आई थिंक टेस्ट नंबर 4 अगर किसी का होगा यहाँ पे, टेस्ट नंबर 5, टेस्ट नंबर 4 सपोज ये हर्षित का देखें हम लोग, जैसे क्वेश्चन नंबर, हर्षित हैव रिटन गुड आंसर्स, राइट? लड़के का होनी चाहिए इस बार. व्हाट आर द प्रॉब्लम दैट अकर्स, ये भी क्वेश्चन पूछा हुआ है, ह्यूमैनिटेरियन लॉ का भी इसमें भी आया था क्वेश्चन. वेरियस टाइप इंटरनेशनल लॉ, पीसफुल सेटलमेंट, ये क्वेश्चन मैंने कहीं ना कहीं पूछा हुआ विद रिगार्ड टू दिस. क्या चलिए आगे देखते हैं. ओके, सो हाउ विल यू स्टार्ट विद दिस क्वेश्चन? सो वी विल स्टार्ट विद किसी international law. The purpose of international criminal court is that individual should be, should not violate certain crimes, so individual can be prosecuted for certain crimes. And then you will write what is the foundational structure of ICC, right? So you will write Rome Statute and how Security Council actually may refer matter to the ICC, right? And then you will, these things has to be written in one para, that's it. Because the main question is with regard to that it is more Eurocentric, right? So you have to start with the criticism, right? So African bias, a European bias, right? Powerful states are not the members. You can write the example, right? Then you can write Security Council will refer the dispute, and if there is a veto, obviously the dispute cannot be referred. The best example is actually Russia, right? Recently you will write also that recently arrest warrant was issued with regard to President Putin, but cannot be executed. That itself identifies the limitation inherent in ICC. Okay, again quite a simple thing. Then you can also talk about this power dynamics, or geographical focus, right? You can also talk about how most of the jurists appointed in this court is basically of European origin, right? So they have a preconceived notion of understanding of the actual ground realities. Okay, along with one examples. Okay. In fact, one thing you can also write, like the question that I have given in test that I could not find, I think in test number 3 something, somewhere it must be, that the question that I has framed was that after the threatening of United States, ICC has become irrelevant. Okay, because United States have recently threatened, if you arrest any of the member of the United States Army, this ICC people, then I will issue arrest warrant against all the member of ICC. Right? So that itself has devalued the whole of the ICC. Okay, so that, I mean, that is why I have asked that particular question. So quite interesting. Okay, let's come to question number 6A. ये बात समझ में आई everyone? Yes? आगे बढ़ा जाए. Okay. चलिए. Now let's come to question number 6A. It says कि law must be stable, yet it cannot still that it needs to reconcile conflicting need of stability, change in fast developing world. Stability appears to have become casualty international law. Differentiate between traditional international law and Indian. Right? Basically, that is asking basis. Initially, international law was based on positivism. Now, new reality has come up. यही मैं कह रहा था. It is similar to the question number 5. Some part, obviously, not everything is similar, right? So, what you have to talk about? You have to talk about traditional view of international law. What are the major things in the traditional view? Sources, state-centric, emphasis on sovereignty. Mostly it talks about predictability or stability. And then you will talk about modern view. right? A new view. Diverse sources, individual as a subject, human rights and enforcement mechanism has become a matter of concern, right? Technological progress has led to transnational effect of the laws, which was not there when it was quite a state centric or when new development has not taken place, right? Getting my point? So you have to simply identify major headings with regard to traditional, with regard to new, and simply explain them along with some jurist or some code that you can remember. Okay, star view, very correct, very correct. A star view you can write OSS. Very correct. A star view you can very easily write it. Okay, so again a very easy question, right? Again a very easy question. Chaliye. Now let's come to question number 6B. It states so considerable flexibility in procedure whereby giving effect to the rules of international law within that. कितना खतरनाक क्वेश्चन है. Basically monoism and dualism पूछ रहा है. ठीक है. You have to write कि okay, international law seems like weak law unless it is applied by the state legislation. There are two group of views. One is the monoism, which says both law is same, so it is irrelevant for whom it is made, and second is dualism, right? And then you can also mention that there are other independent, or you can say mixture of these two, specific adoption, transformative theories. Simply mention them, comma. Then you can write in India, the state mostly follow dualism, and it can become the part of national law either through executive act or through legislative acts. So executive acts, Article 73, legislative acts 251. Okay, that you can make a law for the purpose of international cooperation. And then you can simply fill it with the cases, right? So there are 2-3 cases. Gramophone, very correct. Gramophone is a very correct case, right? Similarly, Justice Khanna talked about this in this case of Sankri Prasad also, they have talked about. See, one of the argument that was made in Sankri Prasad that the word law under Article 13 also means international law. The court said no, right? It is not the case. Similarly, Visakha, persuasive value, you can write this separate heading, persuasive value, and write Visakha guideline as one of them. Yes, very correct. Similarly, वो भी तो case है ना that Vargsri, George Vargsri, that mensria wala case in the case of this crime. वहां भी they said कि okay, international law should apply. The court said that no, until there is a specific domestic legislation, international law will not apply. Okay, so in the case of conflict, Indian law will prevail, right? So along with lot of 3-4 cases, yes, you can simply write it. Again, quite an easy question. Now I will be making solution for them. Okay, right now I'm simply discussing it, and I think one of the solution maker is a part of this meeting also, right? He is listening and making notes, hopefully. ठीक है, तो सुन के notes बनाइए and you make a overall solution, right? And then I will revise it. Obviously, it will take almost, by tomorrow evening I will do it, right? So they have also published a book, right? So if you want to buy, you can buy. Okay. Now, distinguish between continental self and exclusive economic zone. सीधा क्या करना है? And clause so and so articulate have been provided, and then you simply go on and make a basis, exclusive economic zone, continental self. Write the basis and write this. This is one you have to write it. Okay, nothing else is required. Quite simple, to the point. Yes, 57 and clause and others. Very good. Then come to 7A. Preamble of UN Charter is representative of aspirations of humanity in ensuring peace. See, एक बात मैं आपको I will advise you, everyone who is listening, is it is the same thing. Some of the parties, Himanshu, are very connected, some of the parties exactly the same. लेकिन वहाँ पे contiguous zone में they have asked Indian scenario क्या है? यहाँ पे they have asked with two different things. Okay, Himanshu is asking how this question is different from contiguous zone question. So contiguous zone में they have basically asked Indian provision क्या है? यहाँ पे इन्होंने only on clause पे बात की. Okay, Himanshu, otherwise okay. तो एक चीज सॉरी जो मैं बता रहा था कि जो आर्टिकल 1 एंड आर्टिकल 2 जो है यूएन चार्टर का पर्पस एंड प्रिंसिपल, दैट इज एक्चुअली क्वाइट एन इंपॉर्टेंट आर्टिकल. वो इतने जनरली लिखे हुए हैं कि 3 टाइप ऑफ क्वेश्चन यू कैन यूज. फर्स्ट, सपोज देयर इज अ क्वेश्चन विद रिगार्ड टू डू यू थिंक इंटरनेशनल लॉ नीड्स स्ट्रेंथनिंग? तो यस, क्या प्रॉब्लम है? सॉवरेनिटी वायलेट, ठीक है, रिकोर्स टू फोर्स हो रहा है, पीपल आर नॉट एडहेरिंग टू पीसफुल सेटलमेंट ऑफ डिस्प्यूट्स, राइट, उसमें यूज कर सकते हैं. सेकंड, कि व्हाट आर द थिंग्स दैट नीड्स टू बी डन for international law to strengthen international law. तो वो limitation में negatively लिखिए. Positively, what are the things that needs to be done? तो वहां पे ये लिखिए. Should not interfere into the sovereignty. Should resort to the peaceful settlement of dispute. Okay. So this article 1 and 2 is actually quite a good thing, right? So same thing here they have asked, right? So there are almost 10 to 12 principles in Article 1 and Article 2 of UN Charter. You simply memorize them along with the sub clauses and give them as a head. जो मैं आंसर जो यहाँ बना रहा हूँ, ये वाला आंसर तो मैंने हालांकि बना भी लिया है, right? So you have to simply write those sub clauses and simply explain them along with the article, obviously. कि Article 2, Clause 1, Article 2, Clause 2. Getting my point? ये बात समझ में आई है? So this Article 1 and Article 2 can be used in 3 type of questions: limitation of international law, improvement that can be done in international law, or what is the objective that can be done to achieve. समझ में आ रही बात ये? Yes or no, everyone? Purpose and principle, right? So this is something very important. जो लोग फाउंडेशन में ऑलरेडी होंगे, right? I mean जो लोग इंटरनेशनल लॉ पढ़ चुके होंगे, right? They must have seen कि आप मैंने कहा है कि you buy this UN charter. Actually quite important. चलिए, now let us come to question number 7B. देखिए 15 मिनट ही बचा है, तो कोई बात नहीं. टुडे आई विल डिस्कस पेपर 1, पेपर 2 2-3 दिन बाद डिस्कस कर लेते हैं. ओके, सिर्फ पेपर 1 ही आज करते हैं. मुझे लगा था 1 घंटे में हो जाएगा, लेकिन ऑब्वियसली नहीं होगा. ओके, सो लेट अस ओनली डिस्कस पेपर 1, पेपर 2 कल का. ठीक है ना? ओके, कल क्या मतलब मैं बता दूंगा उस ग्रुप में, सॉरी टेलीग्राम ग्रुप में. आई विल सेंड यू अ मैसेज. 2-3 दिन का समय दीजिए. आफ्टर दैट आई विल डिस्कस इट. ओके, मुझे इसके सॉल्यूशंस बनाने हैं ना, वो छपनी है किताबें, राइट? तो आफ्टर दैट डिस्कस. ओके, चलिए, नाउ लेट अस कम टू question number 7B. 7B, I'm coming. Chaitanya, quality not. Yes, Chaitanya, very correct. 7B, reservation in multilateral treaty excludes or modify legal effect of certain provision of the treaty in application to that state. Explain the circumstances under which reservation in treaties are permissible. अगर मैं वही क्वेश्चन लिख दूं, राइट अ शॉर्ट नोट ऑन रिजर्वेशन, तो ऑलमोस्ट 90% चीजें सेम. थोड़ा सा सिर्फ यहाँ पे जो डिफरेंस है, दैट इज you have to little bit focus on in what condition state can be allowed to come up with reservation. Like there's a specific provision in our VCLT that if the treaty provides, then only the reservation can be granted. If treaty do not provide, reservation cannot be granted. So that part has to be focused. Otherwise, everything will remain the same. Otherwise, everything will remain the same. Now, let us see how to approach this question, right? So we will start with meaning of reservation, definition. Reservation is defined as a unilateral statement. This part is very important, right? VCLT defines reservation as a unilateral statement, but it means it is done given by a state unilateral. Okay, and then you will go on and talk about different clauses of VCLT, right? Express permission is needed, Article 19A. Then implicit permission, if not provided, then obviously would not be given. If it is restricted, would not be given. It will be governed by the, reservation cannot be against the object and the purpose of the treaty, Article 19C. Then you can also talk about reservation can be withdrawn by the states, Article 22, right? So simply write these provisions along with in bracket article and simple explanation, layman explanation. ऐसा नहीं कि you write exactly the treaty provision. A layman explanation is also more than sufficient. So right? So these 4-5 clauses along with the explanations and article is more than sufficient. Example दे सकते हैं, जैसे आपका जो NPT है, this non-proliferation treaty 2017, that specifically says कि no reservation shall be provided, right? So in that no reservation can be given. Getting my point, right? So you can simply cite some of the examples like that, like the hijacking provisions जो treaty अभी sign हुई है, that also talks about no reservation is allowed. Obviously no reservation will be there. Right? So वो part थोड़ा सा focus करना है along with certain examples. Otherwise, write a short note or reservation would be more than sufficient, right? The content would remain the same. ठीक है, everyone? समझ में आई बात ये? आगे बढ़ूं मैं? Yes, Vartika is also here, I think. Okay. I mean, I don't know whether it's the same foundation batch, Vartika or someone else, but yes. चलिए, now let's come to 7C. Lawful recourse to force or aggression. Again. क्या मैंने बताया कि टू जब भी ऐसा है लॉफुल रिकोर्स टू फोर्स, तो स्टार्ट कीजिए. यूएन चार्टर प्रोहिबिट करता है आर्टिकल 1 एंड आर्टिकल 2 जो मैंने कहा. एंड दिस है कस्टमरी इंटरनेशनल लॉ, कैरोलाइन इंसिडेंट, certain limitations, and the limitation is provided in Article 51 of Human Charter that says the state has inherent right of self-defense in the case of armed attack. Okay, in the case of armed attack. Now, what is the meaning of armed attack? There are 2 categories of jurists. One category of jurists says it has to be an actual armed attack. ठीक है. Second category of jurists says that no, it can be a perceived armed attack also, meaning you have a preemptive self-defense also. ये बात समझ में आई? There are two group of jurists कि what is the meaning of armed attack under Article 51 of the UN Charter? First group of jurists says actual armed attack होना चाहिए. Second कहता है कि नहीं, perceived armed attack में भी आप self defense exercise कर सकते हैं. It means कि you have a preemptive self defense also. समझ में आ रही बात? ये clear है? Understand, right? So you have to simply justify क्योंकि when you can have. Now if you want you can also talk about limitations. Although limitations पूछा नहीं है लेकिन लास्ट में एक दो लाइन लिमिटेशन लिखने में कोई दिक्कत नहीं है. क्या limitations है? So कैरोलाइन में humanitarian law का limitations है, and in the case of Article 51, if the Security Council has taken cognizance, if your right to self defense is to exist. Okay, समझ में आ गया स्ट्रक्चर इस आंसर का? एवरीवन स्ट्रक्चर समझ में आया इस आंसर का या नहीं आया बताइए? यस, फिर से रिपीट कर दो. विनायक कह रहा है लिखेंगे कस्टमरी लॉ में सेल्फ डिफेंस कैरोलाइन इंसिडेंट से आता है, उसके लिमिटेशंस क्या है, प्रोपोर्शनलिटी एक्सेट्रा. सेकंड में लिखेंगे आर्टिकल 51 से आता है. 51 में है कि स्टेट हैव ए राइट टू इनहेरेंट सेल्फ डिफेंस इन द केस ऑफ आर्म्ड अटैक. आर्म्ड अटैक में दो व्यू पॉइंट, पहला होगा एक्चुअल आर्म्ड अटैक एंड सेकंड है दैट इज योर परसीव्ड आर्म्ड अटैक. इट मींस दैट प्रीएम्प्टिव सेल्फ डिफेंस भी है आपके पास. ओके, एंड देन यू राइट द लिमिटेशंस इवन इफ यू कैन स्किप द लिमिटेशन दैट इज आल्सो. ठीक है, वही तो स्ट्रक्चर बताया ना कि भाई लिखिए आर्टिकल 1 और 2 प्रोहिबिट करता है, देन यू राइट कस्टमरी इंटरनेशनल लॉ में प्रोवाइड करते हैं सेल्फ डिफेंस के राइट्स, एंड आर्टिकल 51 में प्रोवाइड करते हैं, और दोनों को इंडिविजुअली एक्सप्लेन कर देंगे. ओके चैतन्य, तो फाउंडेशन में फिर मैं पढ़ाऊंगा भी, अगर आपने ये नहीं पढ़ा तो नोट. ओके, समझ में आ गई बात सबको? आगे बढ़ते हैं फिर हम. चलिए नाउ लेट्स कम टू क्वेश्चन नंबर 8A. अब ये देखिए, ये बड़ा अच्छा क्वेश्चन था, है ना? जो जो पढ़ा होगा उन्हीं को समझ में आएगा. WTO provides agreement amongst its member from which forms foundational of gold legal foundation gold. Evaluate the importance of WTO and new international economic order. एक हम लोग का टॉपिक है NIEO और एक टॉपिक है आपका WTO. तो मैं बार बार कहता हूं कि GS में NIEO टॉपिक नहीं है, लॉ में. ये NIEO है क्या? तो बेसिकली NIEO इज बेसिकली वन ऑफ द रेजोल्यूशन ऑफ सिक्योरिटी जनरल असेंबली. Even after independence of 1950s or 1960s में the countries which got its independence they could not develop, right? तो क्यों नहीं develop हुआ? So General Assembly passed a resolution said that see all the economic institutions which have been made, they are not giving proper access to the newly developed country, so they need to adhere to certain principles. Now there are 17-18 principles, लेकिन तीन मेजर चीजें हैं इसमें. पहली चीजें क्या है कि there is a historical responsibility of the developing country to acknowledge developed countries to acknowledge the historical wrongs. Second, they have to give preferential access to the developing country in the terms of trade. And third, they will not demand reciprocal treatment. Right? बहुत सारे हैं लेकिन ये तीन मेजर फाउंडेशनल है. अब जो WTO है इस तीनों को प्रोवाइड करता है. WTO में इफ यू रिमेंबर, इफ सम ट्रीटी साइन, डेवलपिंग कंट्री को 10 साल मिलेगा उसके प्रोविजन को फॉलो करने के लिए, डेवलप कंट्री को 5 साल, तो प्रेफरेंशियल ट्रीटमेंट मिल रहा है. If you remember, there is a general agreement treatment that was given to general preferential treatment that was given by the US to India. ठीक है, तो वो भी एक तरह से देखा जाए प्रेफरेंशियल ट्रीटमेंट. रेसिप्रोकल ट्रीटमेंट डिमांड नहीं करेंगे, राइट? सो डेवलपिंग कंट्रीज कैन नॉट, सो डेवलप्ड कंट्री कैन नॉट डिमांड रेसिप्रोसिटी. रेसिप्रोसिटी इज वन ऑफ द फाउंडेशनल एस्पेक्ट ऑफ WTO also. राइट, तो आपको क्या करना है कि WTO के प्रिंसिपल्स लिखने हैं, क्योंकि दीज आर द प्रिंसिपल ऑफ WTO, that these are the mechanisms or legal foundation of WTO, and then you have to connect with them with the principle of NI. ठीक है, तो अगर आपने इसको ठीक से पढ़ा नहीं है NIO प्रिंसिपल और WTO के प्रिंसिपल को, तो नहीं कर पाएंगे. ठीक है, तो NIO प्रिंसिपल्स हैज टू बी कनेक्टेड विद द प्रिंसिपल्स ऑफ WTO. इसके आंसर भी मैं इनफैक्ट बना चुका हूँ, राइट, वेयर आई हैव ऑलरेडी very nicely have compared both of them, right? इस पर्टिकुलर चीज का मैं आंसर बना चुका हूँ. इनफैक्ट मैं आपको थोड़ा सा मैं दिखा भी सकता हूँ ये पॉइंट, right? I can actually show you this answer also. let me show you this answer. Give me a minute. This answer actually I can show you. ये दिख रहा है सबको ये? Can you guys see this answer? Yes? ये इनफैक्ट मैं बना भी चुका हूँ, ठीक है, कि मल्टी ट्रेडिंग सिस्टम एनआईओ के प्रिंसिपल थे, डेवलपिंग कंट्रीज एनआईओ के प्रिंसिपल, ठीक है। एनआईओ प्रिंसिपल हैज टू बी कनेक्टेड विद डब्ल्यूटीओ प्रिंसिपल, ठीक है, इट इज वेरी गुड। ये वाला मैंने अभी बनाया है, ऑब्वियसली सब नहीं बनाया मैंने, लेकिन मैं ऑब्वियसली धीरे धीरे सब बनाऊंगा। ओके, चलिए अब आगे बढ़ते हैं। लेट अस कम टू 8B, member states. No, this PDF won't be given to you, Vidak. This is a PDF which have been made by on the behalf of it is a paid up work by the Facto IAS, right? So the Facto IAS have, will pay me, right? And they will sell you, right? But obviously certain I can send you 1, 2, that's all right. Okay, copyright issues. Catch 8B देखते हैं. It says कि member state of the UN needs to take appropriate action for protecting and improving of human environment. So simply you have to talk about what are the major things. ये देखिए एक क्वेश्चन मैंने इस पे पूछा था, exactly the same question, right? हर्षित का ही कॉपी लेते हैं। देखिए इसमें मैंने लास्ट क्वेश्चन पूछा, इसलिए मुझे याद भी है, ये मैं बहुत बच्चे को दिखाया भी है कॉपी। इसे ये क्वेश्चन देखिए, enumerate the major international effort for human environment, ये क्वेश्चन हो गया, ठीक है। And what is the question that they have asked? See the second question. The question that they have asked is major steps that have been taken. ठीक है, स्टॉकहोम कॉन्फ्रेंस से स्टार्ट करेंगे, वेरी करेक्ट, आर्या बिल्कुल सही कह रही है। उसके बाद में क्या बताएंगे, बहुत सारे हैं, बर्टलैंड कॉन्फ्रेंस देख सकते हैं, रामसर कन्वेंशन लिख सकते हैं, राइट, दिस यूएन कॉन्फ्रेंस ऑन एनवायरमेंट डेवलपमेंट लिख सकते हैं, वर्ल्ड बैंक सस्टेनेबल समिट, बहुत है, सस्टेनेबल डेवलपमेंट गोल्स, लॉट ऑफ थिंग्स यू कैन राइट। अभी जो रिसेंटली यहाँ पे न्यू दिल्ली डिक्लेरेशन जो आया था विथ रिगार्ड टू डिजर्टिफिकेशन, थोड़ा सा इंडियन भी हो जाएगा उसमें, ठीक है, वो लिख सकते हैं, राइट, नोएडा डिक्लेरेशन ऑफ डिजर्टिफिकेशन, यूएन कॉन्फ्रेंस दैट हैज हैपेंड, राइट, आई थिंक 2022 में, ठीक है। तो मतलब बस इसमें आपको कुछ नहीं, कॉन्फ्रेंसेस भरने हैं बस, लाइन बाय लाइन, लाइन बाय लाइन, कॉन्फ्रेंस ईयर ये हुआ था, ओजोन लेयर किसी लिख रहा है वो भी करेक्ट है, वेरी करेक्ट, वो भी लिख सकता है, लेकिन स्टार्ट स्टॉकहोम से करेंगे, वो बिल्कुल सही कह रहे हैं आप, मैन एंड यूनाइटेड नेशन कॉन्फ्रेंस ऑफ ह्यूमन एनवायरनमेंट 1972, ठीक है, दैट इज एक्चुअली यूनेस्को वर्ल्ड हेरिटेज गड़बड़ है, नहीं अरुण वो नहीं लिखिएगा, राइट, मोर रिलेटेड टू एनवायरनमेंट, राइट, बिकॉज दिस इज ह्यूमन एनवायरनमेंट, ताकि उसको भी कनेक्ट कर सकते हैं, लेकिन नॉट वेरी नाइस, डिजायरेबल नहीं है। चलिए, नाउ लेट्स कम टू 8C. International humanitarian law is set to rule limit the effect of armed conflict, where international humanitarian law seeks to ensure set of rights which are essential to humans. Distinguish between international law and humanitarian law in terms of their content and purpose. देखिए ये जो डिस्टिंक्शन है बेसिकली क्वेश्चन में खुद ही दिया हुआ, पर ये क्वेश्चन को क्लियरली खुद ही बता रहा है कि ह्यूमैनिटेरियन लॉ आर्म कॉन्फ्लिक्ट के, इसलिए उसको लॉ ऑफ वार भी कहते हैं, और ह्यूमन राइट लॉ इंडिविजुअल सेंट्रिक, ठीक है, राइट। सो द क्वेश्चन इटसेल्फ कंटेन द आंसर, यू टू सिंपली इलैबोरेट, इस वाले पॉइंट को इलैबोरेट कीजिए थोड़ा और अच्छे से, राइट, तो फिलोसफिकल लाइंस लगा करके ना, नेचर ऑफ इंटरनेशनल ह्यूमैनिटेरियन लॉ लिखिए, नेचर ऑफ ह्यूमन राइट्स लिखिए, क्या है नेचर उनका, राइट, तो कंसिस्टेंट होते हैं, इनडिविजिबल होते हैं, ठीक है। उसके बाद में डायरेक्ट टेबल बनाइए, बेसिस, स्कोप, कंटेंट, ठीक है, सब्जेक्ट, इंटरनेशनल IHL, इंटरनेशनल ह्यूमन राइट लॉ एंड ह्यूमैनिटेरियन लॉ, राइट, HL, सिंपली उनको कंपेयर कर दीजिए, सिंपल। ये तो मुझे लगता है मॉडल आंसर में करंट अफेयर में मैंने कितनी बार दिया ये क्वेश्चन, कितनी बार नहीं, 1-2 बार तो मैंने दिया ही, ठीक है। तो ये क्वेश्चन बस वही क्वेश्चन है, राइट, तो अगेन इट इज क्वाइट सिंपल, ठीक है। अच्छा हाँ, ये रहा 2 किताबें, अच्छा इन्होंने इसमें भी डाल दिया हुआ है, ये 2 किताबें पब्लिश होगी, ठीक है, ध्यान रखिएगा। एक ये ऑलरेडी मैंने पिछले साल लिखा था, तो जिनके पास ये है वो सिर्फ ये ऑर्डर कर लीजिए, ठीक है, और जिनके पास नहीं है तो ये 2 किताबें आपको मिलेंगी, ठीक है, आई थिंक 1500-1600-1700 रुपए इनका कीमत है, राइट। सो 5 साल की ये हो गई, 14 से 17 से लेके 23 तक जो लेटेस्ट वाली है, और ये हो गई उससे पिछले 5 साल की, राइट, तो टोटल 10 साल की किताब है। अगर मेरी मानो तो इस 10 साल के अलावा कुछ नहीं चाहिए, ठीक है, 10 साल में ऐसा कोई क्वेश्चन नहीं होगा जो आगे चल के रिपीट नहीं होगा, ठीक है। नहीं नहीं, सारा ईच बुक 750 का नहीं है, फिर आदमी दुखी नहीं खरीद लेगा, ठीक है, दोनों बुक 1750 का, राइट, ठीक है। तो देख लीजिए, अगर मूड है तो ले लीजिए, और नहीं तो दुखी खरीद के खुद भी इसका सोल्यूशन बना सकते हैं, कोई बड़ी बात नहीं, ठीक है, दैट इज हाँ, इट इज वेरी एम्पली मेड, बहुत अच्छे से मैंने बनाया है ना, प्रॉपर जो कहते हैं ना, प्रॉपर मैंने, ठीक है, सो नॉट टू वरी अबाउट इट, ठीक है, वेरी नाइसली आई हैव मेड ऑल ऑफ अच्छा, ऑर्डर कर लिया है, ठीक है। चलिए, कहाँ से ऑर्डर करेंगे, कोई पूछ रहा है। books.defactois.com, बुक्स है, ठीक है, बुक नहीं। defactois.com पे जाइएगा, वहां पे रहता है, ठीक है ना, तो जाके वहां से खरीद लीजिए। सेंटर पे मिल जाएगा क्या? सेंटर पे हाँ मिल जाएगा, मिल जाएगा। नेक्स्ट फाउंडेशन की बैच कब स्टार्ट होगी? अरे यार, ये सब उनसे पूछो। कॉल डिफैक्टो वाइज पीपल, ओके अरुण, ठीक है। ईमेल करो उनको, defacto.law.in पे जाओ, व्हाट्सएप या ईमेल करो, वो बताएंगे नेक्स्ट फाउंडेशन बैच होगा, ठीक है ना। हाँ, 2023 के भी सोल्यूशन होगा निष्ठा, वही तो मैं बता रहा हूँ। इसमें देखिए, ये जो है आपका एक बुक मिलेगी जो मैंने पिछले साल पब्लिश की थी, 18 से 25 तक 5 साल का सोल्यूशन। इस साल वाला 2023 का सोल्यूशन, और प्लस 18 से पहले के 4 साल का सोल्यूशन। तो टोटल मैंने 10 साल की 2 बुक बना, ठीक है ना, तो बड़े आसानी से हो जाएगी। वी हैव एक्सेस टू PYQ इन टेस्ट सीरीज प्रोग्राम ऑन पोर्टल। प्रत्युष मिल जाएगी आपको, प्रिंट आउट, सॉरी, आपको खरीदना पड़ेगा, ठीक है ना, यू हैव टू बाई। मुझे लगता है कल शाम तक मैं सोल्यूशन बना दूंगा, कुछ तो मैंने बना दिया है, कल शाम तक मैं बना दूंगा। तो परसों परसों जाके ले लीजिएगा, ठीक है, यू विल गेट इट। एनीवन हैव एनी अदर क्वेश्चन? आस्क, अदरवाइज आई विल वाइंड अप। यस, थैंक यू एवरीवन। विल गेट 2 बुक फॉर 7। यस यस, 2 बुक यार, एक ही बात कितनी बार पूछ रहे हो तुम यार। 2 बुक मिलेंगी, ठीक है। दोनों बुक्स जो है आपको 1750 मिलेंगी, ओके। वर्ड लिमिट तो ऐसा, यूपीएससी इटसेल्फ हैव सेड कि 150 वर्ड्स अराउंड 10 मार्कर के लिए होता है, 15 मार्कर के लिए अराउंड 250, और 350 20 मार्कर। अभी ओवरऑल गाइडलाइन है, 10-20 मार्क्स इधर उधर, नंबर इधर उधर, कोई दिक्कत नहीं, ठीक है, दैट्स ऑल। चलिए, तो वाइंड अप करते हैं, और टेलीग्राम पे मैं अगला जब भी लूंगा, नेक्स्ट वीक या इस वीक के लास्ट में, देन आई विल गेट, ओके। कल नहीं विनायक, आई विल गिव ऑन द टेलीग्राम, ओके, आई विल गिव ऑन द टेलीग्राम। Good night, thank you everyone. Yes, this recording I am going to upload. I mean, I will give to the de facto people, they will do some editing all sort of that, and they will upload it, okay. अब कब अपलोड करेंगे यार, मुझे नहीं पता, उनकी IT टीम है, आई थिंक शाम तक तो कर ही दे, ओके। वाइंड अप करें फिर, चलिए, थैंक यू एवरीवन, थैंक यू।